everyone. Welcome to the January 2017 Zoning Board of Appeals meeting, Town of Carmel. The board members' names are in front of you. Town Code Enforcement Officer Mike Carnazza and Town Council Greg Fulchetti are joining us as well. The way we operate is we'll hear the cases, present to the board. I'm going to swear you in. And once we hear the cases and we close the hearing, there's no further input from the public. Not that I think there'll be any input tonight, but please join me for the pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, our first case tonight is asking for an adjournment. I'll look for a motion on that.
Motion
Motion to grant.
Do I have a second?
to hold over?
Yeah, motion.
Hold over, I'm sorry, hold over.
Do I have a
Second
motion?
is second.
To hold it over? All in favor?
Aye.
Okay. That's the second holdover. I guess, I typically kind of give like 3 times. If we get to a third time, then that's, I think
Did
we're
they
just gonna
request it, or did
dismiss
they,
without- He requested it.
did he say he was trying to get more information, or?
My client and I need additional time to respond to the items that the zoning board brought up. This is from,
Yeah.
well, we got it emailed to us. Actually, it's the same letter we got last month. If I request that you hold over Mr. Mazzola's case until January 2000. I didn't realize it's a different date, but it's the same letter that we got, so.
Okay.
All right, so number 2 on the application tonight is Donald and Karen Burns. Come on up. Assume both of you will be speaking?
Karen will be speaking.
Well, raise your right hand. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, let us know what you're seeking relief on.
I'm sorry?
Let us know what you're trying to do.
Basically, we have an existing pool and shed that we requested a variance and permits for
We'd like to keep.
that we'd like to keep.
Okay. How long have the sheds, how long have they been there for?
One of the sheds was a replacement of a pre-existing shed. We had no reason to think that we needed a permit because we were replacing something that didn't have a foundation with another thing that didn't have a foundation built on it.
Okay, so you didn't realize you needed a permit?
The existing one that was there was just old, and we tore it down and put the new one up in the same spot, basically.
Okay, and the pool, how long has the pool been there with the deck?
8 years.
And again, you didn't realize you needed a permit for it?
We went to Orange County Pool and we just
We
bought
had
it.
no idea. I've heard that you've got to have them for the in-ground pools. Growing up, we never had permits. We used to take the thing up and take it down and
Down
put it
there.
up
Take it
from
with
where
us.
we used to move all the
Never
time.
gonna tell you need a permit, they'll lose a sale, potentially, but, so I know you're in a tight lot and tight neighborhood. It looks like everything's screened pretty well. There's no other property you can buy to bring it into conformance?
No.
And what would be the cost to relocate and remake the sheds and the pool and the deck approximately?
I would have no idea what it would cost to, there's nowhere to put, because of the size of the lot.
Right.
We'd have to put the shed, without a variance, smack in the middle
Middle.
of the backyard.
All right, you checked with your neighbors, no complaints, no
Yeah.
issues or concerns?
All the letters were mailed and stuff too.
The sign's been there, posted.
Yeah, and the sign's been posted. We have never had anyone complaining. When we put the pool up originally, we have children. We put the fencing around it so it would be safe, because it is a small lot, and I didn't want people wandering in and jumping over the side,
Pool hopping.
like we used to do, right?
I never did that.
You're under oath?
You know, once or
All right.
twice.
I'll pull the board.
The property's also fenced in completely.
Okay, yeah, we saw it. Rose, any questions?
Why is this coming about now?
Apparently, we were serving paperwork last summer. The reason it took so long to file everything, when we went to file the paperwork, once it was brought to our attention that this was a problem. We couldn't find the survey we had when we bought the house. We work for a living, too. it takes time to save the money
To get the survey
to
done.
get the survey done. And that's basically what the delay was getting the money together to pay for the survey to be completed. That ended up being a lot more expensive than I could have possibly imagined for a piece of property so small. So it took a little bit longer. We had to wait till kind of Christmas bonuses hit. So that as soon as we got that, we called the guy immediately, had it already pre-set up and pre-arranged. He came right over, got it done. We got the paperwork submitted. In the meantime, had everything ready to go. We just waited for the survey. So that was the only like I said, we had no idea there was an issue. Apparently, someone went around and I know the new neighbors next door to us that we're friends with. They had
Google
peop-
Earth is a good revenue source for
Well,
the
that
town of
too.
Carmel.
But the other thing is we had inspectors next door at their house when they bought the house because it was it was under work pending with the sale. It was a foreclosure and all this other stuff. So my guess is someone probably took a look, decided to check. It happens. We had no idea that there was really any issue.
Okay.
So,
No questions, thank you.
No question.
No questions.
Any input from the public on this application? I'll look for a motion to close the public hearing on this.
Motion to close.
Do I have a second?
Second.
All in favor?
Aye.
Thanks, folks.
you don't have to pull
You can
hop.
stick
You
around.
can come by anytime and we'll open the pool to you, okay?
Polar Bear Club, we'll go tomorrow.
Speak for yourself.
All right, next application is the hostess.
Yes.
Folks, come on up.
Good evening.
State your name for the record, please,
Leslie DeHostas.
and raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Let us know what you're looking to do here.
I would like to retain my deck on my property,
Okay? How long has it been there?
possibly over 10 years.
Wow. Okay. There's no property you can buy to bring it into conformance?
I'm sorry?
There's no other property you can purchase to bring it into conformance, correct?
The front yard.
Surrounded by, yeah, the road's on two corners, right?
Yes.
And what is the value of the deck approximately?
I wouldn't know. That's how I purchased it back
so it
in
was-
December
And it was
2013.
never picked up on a title search or anything?
There was a CO on file for a deck, but I guess that when we closed in 2013, they felt that the CO that was already existing in the file had satisfied any concerns. So it wasn't until last month, when we're in the process of selling our home, that when the new buyers actually ran a title search, then that's when we discovered there was a violation for the deck.
Okay, so
Hence, which is why I'm here
selling.
today. Yes,
Okay.
yes.
Just something get through the file, I guess, right?
Yeah, the deck, on the permit, if I remember, it said the exact dimension of the deck that it was approved for, and this is larger and a separate deck on the front of it.
So it just never got picked up?
It went through the title, it slipped through.
Okay. And I noticed that faces the lakeside, so obviously it's more enjoyable to view the lake from. It's not
Yes.
common to have a deck in the front of the house, but I would see that's the reason why.
I guess so. I mean, it's been there, according to the MLS records, as far as it can go back, since 2004. The double deck has been in existence with the similar dimensions.
Okay. All right, we'll start down here. Mark, any questions?
No questions.
Mike?
No questions.
No.
Phil?
No questions, thank you.
Okay, any input from the public on this application? All right, I'll look for a motion to close the hearing.
Motion to close.
Do I have a second? All in favor?
Aye.
All right, thank you.
Thank you.
Good luck. Okay, and last application tonight is Seno Trust. Good evening, folks. It's hard to tell from the...
My name is William Schilling, and I represent the Angelo Seno Trust. With me this evening is Sarah Kaplan, who is the daughter of Angelo Seno and a trustee of the trust, and Michael Seno, who is the son of Angelo Seno and is also a trustee.
All right, Bill, are they going to be speaking?
I don't know. Do you want?
Let me swear you in just in case. Can you state your name? Oh, well, he just stated your names, right? So raise your right hand. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Okay, thank you. Sorry, Bill, thanks.
That's okay. This property is located on 19 Fowler Avenue. It's a 2.5-story building. Its zone is residential. Excuse me. Currently, there are 4 units, all 1 bedroom on the site. The property is serviced by town water and sewer. It is a neighborhood that is predominantly now multifamily, and it was predominantly multifamily at the time my client's father purchased the property. The prior use at the time of my client's purchase consisted of a mixed use. It was a 2-family upstairs, and downstairs was a retail and tile and leather store. That use was in existence at the time of my client's purchase, and my client's purchase was in 1976, and they changed it to a 4-family in 77. What we're requesting is an interpretation of 15647-2 of your code that the conversion from a mixed use to which was the storefront and the 2-family to a 4-family, is a more restrictive use, and in the alternative, we're looking for use variance standards for an expansion of a predated non-conforming use. In support of what we're seeking, I've submitted an affidavit from Sarah Kaplan, an affidavit from William Finney, who is the president of Duke Construction, who is a licensed contractor in Putnam County. No, Duke Construction. We submitted an affirmation of John Porco, who is a retired attorney. I'm sure many of you know Mr. Porco. He was a partner with Mr. Seno when they purchased the property. I submitted a memorandum of law, and I submitted, per your requirements, floor plans and the survey. The facts of this matter is that in the 1970s, Fowler Avenue was in the last stages of what was a mixed-use neighborhood, in that there was a funeral home, and is a funeral home now. There was a rental car and a used car establishment, a gas station. There was an appliance rental, retail, and of course the tile store, which my client purchased. And there were many, many multifamilies at that time. The site was owned by somebody named Stephen Uzelak, who used the downstairs as a store for his tile work, and upstairs were 2 one-bedroom apartments. My client, Mr. Seno, who has passed on, and Mr. Porco purchased in 1976. And Mr. Seno was an accountant, but he had a great deal of knowledge of the construction trade and people, and he was the one that did the actual day-to-day planning and purchasing, and was, according to Mr. Porco, the one who was responsible to get the necessary permits. Mr. Porco was really just the financial part of it, and he was bought out by Mr. Seno a few years after the purchase. They did have several investments together. The record shows that in 1977, after my client's purchase, the commercial use stopped, and that the residential apartments were placed in the place of the store down below. All the bills were kept. I have them in the file. And then it went on until 1983, when the building inspector issued a violation letter. And on the violation letter, there's a note that says, Porco called, now is a 4-family, and requested an inspection. And after that, there's nothing in the file. Mr. Seno passed on in 2014. Mr. Porco doesn't know what happened and why necessary approvals weren't gotten. But there's nothing else in the record in your building file, with the exception that it passed fire inspections in 2015 and 16. In Mr. Porco's affidavit, he said that it was Mr. Seno's responsibility to get the permits. He believed Mr. Seno did in fact get the permits. And Mr. Porco confirmed that at the time he was aware of 6311-1, which allows a non-conforming use to shift to another non-conforming use as long as it's more restrictive. And I can only guess that was Mr. Porco's thinking that all was good, because when you change from a commercial mixed use to all residential, in my mind, it's almost per se more restrictive. So that may explain Mr. Porco's thinking that it was taken care of. But as I said, Mr. Seno died in 2014, and there's no explanation as to why that approval wasn't gotten. Since 1977, the property has been used, I don't know if you can see this, but as a four-family. It's a pretty, I'll pass it over to you when I'm done explaining. This is the front of the building, and the two entrances service one downstairs and one upstairs apartment. And then in the rear, same thing. This obviously accesses the downstairs apartment and upstairs, the upstairs apartment. This is a full shot of the building. You can see it's a pretty formidable building, large in size. And I want to tell this board that there are 4 meters for the 4 different apartments, and I'll pass this around.
Actually, it looks like there's 5 there, no?
I don't know what that.
The 5th one is the landlord's meter, common meter.
Outside lights, that's ours.
So every unit has a meter. It's been inspected by the fire inspector. The property is serviced by town sewer and water. So there are only a limited opportunity for Board of Health violations, in which case there are none. Today in Fowler Avenue is almost exclusively residential and predominantly multifamily. The only commercial establishment that remains is the funeral house. All the other uses that I mentioned, you can just put it there. The retail appliance store and the car dealership and the used car have extinguished. Back in 76, the section was 6311-1. And again, it says exactly what your code says today. It says that a non-conforming use can be modified and changed into another one, as long as in the board's discretion it's more restricted. So I believe with almost no doubt that if they had gone in 76, they would have gotten the relief that I'm seeking today. Currently, the children of Mr. Seno are now looking to sell, and for the first time have discovered through discussions with Michael that it's only recognized as 2 residential units. The issue of the law, we're seeking an interpretation that the conversion of the mixed use from a mixed use rather to a 4-family is clearly more restrictive. The code then, 6311-1, is exactly the same as the code now, which is 156-47A2, which say the same identical thing, which you can convert one to the other, provided it's more restrictive. I submitted a memorandum of law to you. I talked about your interpretive powers. Only this board has the power to interpret your code. And I submitted cases to you that provide regulations are in derogation of common law rights and any ambiguity to be construed in favor of the property owner. So in this case, what existed was a mixed use, non-conforming, with a 2-family upstairs and a commercial downstairs converted to just a 4-family, which clearly, by any standard, is a more restricted use. It's more in keeping with the neighborhood now, it's more in keeping with the code, and it's more in keeping with the neighborhood and the code. I think that no one is here speaks volumes of the fact that this is as it has been for a long time. Nothing's going to change in the neighborhood. For 40 years, it's been in existence. I've provided some cases for you that are on point that say converting from a mixed use to a multifamily is more restricted in a residential zone. And most importantly, or maybe just as importantly, I cited a case which was Rosano, which says the board must apply the law as it exists at the time of their decision. So today's code is what governs your review today, not yesterday's code, but in this case, it may be moot because they're exactly the same. If you want to apply use variance standards, I'd be prepared to speak to it. I think it's easily met. With regard to reasonable return, returning this four-family to a mixed use would be a very, very expensive endeavor. Duke Construction surmises that it may be as much as $200,000 to bring that back to what it was. I would submit to you, secondly, there's simply no viable commercial user for that area. If you look at...
You submit this memorandum or from William Finney, right, with commercials?
Yes.
I reviewed the building and have concluded that converting it to a two-family with a commercial site downstairs would be approximately $200,000 worth of work, given the structural work required? Structural work meaning what? What would you have to?
I'm not terribly technical in these things, but I know that there would be almost a complete need to gut the downstairs to convert it to office and or commercial. I could get an elaboration. I asked him just to take a look. He went through and he said it would be about $200,000 to make it a mixed use again.
But right now, you have a two-family dwelling.
Legally, I have a
So you're looking for, your first thing is an interpretation that it was a two-family with commercial, I assume? I'm just trying to keep them on point, because they're gonna, it's confusing the way it's going
what
right
I'm
now.
seeking is, while the act took place over 40 years ago, that is, you govern your interpretation over today's code. But the act which I'm asking you to determine is more restrictive is an act that took place 40 years ago, that it was converted from mixed use to a four-family. And in that regard, it's a more restrictive use than it was. And so that's the nature of my request to you.
In 82, the code, the map showed that as residential, correct? The left side of the road was residential, right side commercial?
Yeah.
All right.
I also, bringing back a commercial use, there's no viable commercial user for that property. And thirdly, if you look at the nature of the building, it's simply too large to be a two-family, to be profitable and to be viable.
You had that motor vehicle, please.
I provided cases to you that provided that when you're doing your financial review, if the neighborhood won't change, the necessity of showing economic hardship is reduced. In this case, there's absolutely no change in the neighborhood. The use has been in existence since 1977. Therefore, the nature of and the extent of the hardship is reduced under these circumstances. With regard to uniqueness, this is a unique history. It was modified 40 years ago from a mixed use to a four-family. I submit to you that it's a town priority to extinguish commercial uses in a residential zone, which is what they did back in '76. With regard to the neighborhood, that's the easiest one. There is no change in the neighborhood. All multifamilies are in the area, 40 years in existence. No one here to oppose. A negative decision here would unnecessarily uproot and displace at least two families. And I submit to you, Fowler is one of the few areas in our town that is predominantly multifamily. That's certainly in the hamlet, and I would suggest maybe in the whole town of Carmel. This is heavily multifamily and a place unique for people who have limited financial means. Self-creation is difficult to speak to because my client who would be able to attest to this is not with us. But in any event, there was a good faith made. Mr. Porco letter to the town in '83 saying, come and make an inspection. For whatever reason, was never followed up. We don't know. So in conclusion, I'm saying you're going to be achieving a town priority, which is the formal elimination of the commercial use and exclusively residential use, with an area that is almost exclusively multifamily. It is more restricted in the 70s. It's more restricted today by your code. And if you are not interested in making an interpretation, I would welcome the implementation of use variance standards, because in this case, I believe we meet those standards. We'll answer any questions you might have.
Okay, if we determine that that's the case, that to go the route of a use variance, it would have to be, we would have to deny it and refer it to the planning board
For multifamily,
for multi-tenant, right?
if you don't get the interpretation. They would have to be lead agency before they can make a decision on
Right,
this
and
also.
then they would deny to this board back again.
Well, if I could just respond to that, and I'm an advocate, of course, but
It was done without.
with all due respect, I don't know how the use that was terminated and the one that's implemented today is not more restricted. I spoke to Mike the other day, or maybe today, about the appropriate standard. If you build a deck in the 70s and you don't get it legalized, and you come to get it legalized today, you're being applied contemporary standards. Similarly here, there was a conversion made, nothing done. We're here today to get an interpretation as to the act that was done 40 years ago. It's not an uncommon thing for Mike to apply in his work, or for this board to apply in your work.
And Mike, you verified in your research that no one made that inspection for whatever.
There was no follow-up after that note on that notice of violation. That was the last note.
Right, by Marge Agor at the time, or.
Now, the problem is, correct, what you said now, it's now a commercial zone. Correct?
It's a residential zone.
Commercial zone. Fowler Avenue is commercial on both sides. Zoning district-wise, not use-wise.
Okay.
All right, now, just in looking at the schedule of district regulations, the mixed use is permitted. Multifamily is not permitted in the commercial zone. So either way, I think, I mean, correct me, it sounds to me like it's a use variance either way, to be honest with you.
On interpretation or straight up?
Because if it wasn't done legally, then interpretation at the conversion of a commercial storefront with 2 residential units, the commercial storefront wasn't legal that we can find. Okay, so that means that the mixed use wasn't there legally.
The mixed use you're saying was a legal use back then?
Would have been illegal because it was residential in 82. I don't know about 72. I don't have that map in my head. I had it on my wall until 2002, so. But either way, the 4-family is multifamily. 1 and 2 family or 1 and 2 family, that's a separate thing.
Right.
When you hit that over 3 families, it becomes multifamily. If that's not a permitted use on this district regulation
Right.
schedule, it's not permitted, so it's a use variance either way.
Well, that's why I came to this board with use variance standards as well. And I know that the typical review is, how much is the rent and what are the taxes, but there's another part of economic hardship, which is unnecessary work to be done to convert it into something that has no viable purpose, no viable function. The construction to return it to a mixed use or even a 2-family is substantial. And there's nothing to be gained, and the economic hardship is reduced because the neighborhood won't be changed because it's been in existence for over 40 years. My client wishes to mention, and if you look at
That's the only thing that's
the
permitted.
photo there, immediately next door to my client is a 6-family.
82 is what we always used.
And Michael, this structure is a legal 6-family? That you're aware of, or no? Immediately to the right.
I don't know who's next to, I'm sorry, I didn't look at the
I
lots.
said to the board, Mike, that the immediately next door structure is a 6-family, and I have
And it may be, I just don't have that information in front of me, I don't want to guess it.
6 meters for that particular structure.
Correct, that's correct.
closely.
Yeah, those are gas meters. They're not electric meters. Still.
I don't think, I can't even look it up on Municity, I don't know how.
So I'll read your application. You're seeking permission to interpret that the conversion of a commercial storefront with 2 residential units to 2 additional residential apartments was more restrictive, whereas Mike is stating that a mixed use is more restrictive.
But Mike is also stating that the storefronts weren't permitted in my file.
Right, as the record
It
shows.
it was a,
So
it
the
was a
burden-
non-conforming use, correct?
Agreed, but there should be a note in the file. They got a building permit that said, add to the back of existing two-family dwelling, not add to the back of or rebuild, I'm sorry. used the
I
wrong word.
understand.
Not rebuild the back of two-story building with apartments and commercial.
Well,
It was specifically two-family,
So it was illegally converted to commercial use.
according to my file. I'm not,
And
you
then
know, it could have been
converted to
before they
to a
bought it,
four-fam-
that's
a multifamily in a,
commercial or residential
I-
zone is
I would s-
illegal
I
either
would
way.
think, that question I'm not sure about, Mike, because I think that at the time she wrote the letter, the commercial use had been, it was in 77 when my clients owned it. So it became a two-family in her eyes because the storefront had gone away immediately upon the sale. At least that's my interpretation of it. Now there's downstairs, it's nothing, but they recognize the two families upstairs, you know? I don't think, I don't think it's plausible that that store, which I remember, all this time would have been illegal. I don't believe that. I don't think that's feasible.
Leather and tile or something like that.
I think that letter from Marge said, the store's been abandoned, you have a two-family dwelling now. The problem is clearly this, the records are barren. We're all interpreting what might have been said, but what might have been done. The bottom line is, Michael's interpretation is that the mixed use was not a legal use at the time, and we converted it to a more restrictive use regardless of the zoning. It is a more restricted use. If you accept the fact that the storefront was legally there as a non-conforming use, then what we did is more restricted. What was done then is more restricted.
all right, I'll open it to the board for questions at this point, unless you have anything more.
No.
I said
Is the house fully occupied right now?
Yes,
All 4 apartments?
yes.
end of site plan.
Questions for me? No questions.
Bill?
Yeah,
No questions.
okay.
Can I just get clarification on this?
I hope so.
The only way this was legal was
With the store or the four-family?
back in the 70s.
Yeah, the store or the conversion to a
The
four-family?
entire building. The
To
only
four
way
family.
it would have been legal was if it was just a two-family house. That is the only way it would have been legal back in the 70s.
That's the way I read my record and the assessor's record.
So it was in violation for 50 years. Right? How was it taxed?
I don't have the tax rolls, what?
The 82 tax was residential. It was one family, converted to two-family before 82, I believe, and you were allowed to do it up to 82. And that was the only thing that was recognized on the old card at that time, up to 82.
My clients want me to say that forever it's been assessed as a four-family for what that's worth. But to your point, I understand Michael's interpretation, but I would say just as likely an interpretation is that when Marge wrote that letter, it was after the closing took place, and my clients immediately converted to a four-family because they wanted, Mr. Seno wanted to house his mother there. At that time, when Marge wrote the letter, she says she recognized it as a two-family because there was the use below was abandoned, was extinguished. So if we take Mr. Seno and Mr. Porco's affidavit in words that it was a commercial establishment at the time of the sale and then abandoned, and we agree that a mixed-use house is less restrictive than a four-family, then I think the interpretation is sound.
Okay?
Yeah,
Is that the non-conforming section of the code you're using? Is that what you're talking about?
yeah. 15647.
But that's a variance that's required to be granted.
That's an interpretation where you can go from one non-conforming use to another, as, provided it's deemed to be more restrictive.
And I don't have it in front of me, I'm not, but I believe it says the board may, if in its opinion, find it more restrictive,
Yes.
grant the variance.
Yes,
Not the interpretation.
it's an interpretive statute. It's subject to their interpretation as to whether it's more restricted or not. 15647 to 82, I think it is.
One 15647 what?
Hang on. I have the 15647 too.
Change to another non-conforming use without approval from the Board of Appeals, and then only to a use which, in the opinion of the board, is of a more restrictive nature. So
Right.
they can grant the variance if it is interpreted to be more restrictive. That's,
Okay.
it's not just an interpretation, it is a variance.
Okay.
All right, so which goes back to if it's going to be a use variance, we'd have to deny it and refer it to the planning board.
You don't have to deny it, what you can do is hold it and let them go, refer it to the board.
Refer it to the planning.
Let the,
What would the planning board's role be in a referral without a decision from the board?
all uses of land except 1 and 2 family dwellings require site plan approval from the planning board.
I know, but my question is this: we go to the planning board uncertain as to what the zoning board is going to do.
That's correct.
They could make a decision
They will
this
be-
evening, but I think I think a zoning board has the right to make a decision on interpretive matters and then send it to the planning board for whatever, waiver of site plan or site plan review or whatever it is.
They can interpret and they can do area variance, but not use variance,
Okay.
right? Because the use variance has to be they have to be lead agency. The planning board is the lead agency on that. They do the seeker and they do everything on that.
So they'd have to file a site plan.
Show that they have parking and all the other requirements that are on the site plan, and then go forward from that. Yeah, they could waive things, they can move it right along, whatever it is, it's up to them. That's not,
Well, I would ask you, under the circumstances, in a complex that's been in existence for 40 years, I would ask respectfully for the interpretive powers and an area variance to be granted. Requiring site plan approval under these circumstances strikes me as unnecessary.
I go by the guidance of town council and our building inspector.
What's the area variance reference? I just heard an area variance.
Michael, 15647 provides that they can, if in their opinion, it's a more restricted use, then they can grant the variance.
But it's still use in nature. That's the non-conforming uses section.
I don't think it is, Greg.
I think the section
Well,
is entitled
non-conforming
non-conforming uses.
Read it again, 15647.
47 is non-conforming
Yeah,
uses, I
the-
think.
Article 5 is non-conforming uses.
Right.
Which is that whole,
Okay, all right.
I don't think that's a use variance.
It
It
was
can be
number
changed
2,
from one.
change to another non-conforming use without approval from the Board of Appeals, and then only to use which, in the opinion of said board, is of more restricted nature.
Right, I don't think that's a use variance. I'll go back to the fact that I think it's primarily an interpretive power you have to determine whether you think that that use is more restricted than what was there at the time it was replaced.
The entire section says, any type of non-conforming use of buildings or land may be continued indefinitely, but shall not be, and then we go to 2,
Right,
change to another non-conforming use
right,
without approval from the Board of Appeals.
right,
And then only to a use which in the opinion of said board is more restricted.
Right. I don't think that compels one to apply use variance standards. I think it's an interpretation of this board that it's a more restricted use. That's not, to me, that's not application of use variance standards, that's your interpretive
Where you need a
powers.
site plan. It triggers another, the problem is it triggers another component of the code because of the four-family. That's all. And I think probably waive site plan, but, or waive public hearing or something, but.
Okay, so we have to make an interpretation first,
Public hearing. Yeah,
as a board.
public hearing and stuff like that.
and then whatever's decided, we'll have to, we'll have a choice, we have to refer it to planning board.
Are you saying that you can interpret it without referring to planning, or that,
Well, you're seeking an interpretation that the conversion of a commercial
Right.
storefront with 2 residential units to 2 additional residential apartments
right,
was more restrictive, period.
Right.
And the alternative, applicant seeks a use variance to permit
right,
a 4-family structure. So I'm reminding the board, whoever's gonna make an
Except one and
interpretation,
two-family dwellings, was they
that-
converted back to a two-family dwelling, they don't need site plan.
that this would have to go or be referred to the planning board
So
if
if I'm in R, I don't make a
a
two-family.
use variance is determined.
right. If you determine
And without a
that
site plan.
the interpretation we're requested
It triggers it.
is not something you're prepared to do, and you think it's a use variance question, then you have to send it to planning.
Right.
But if your interpretation is that it is a more restricted use, and I submit to you, by any review, in a commercial use, which was the store, converted to residential, it almost per se is a more restricted use. I mean, and it brings it more into compliance with code and more into compliance with neighborhood.
Yeah, it's a sticky neighborhood because part of it is residential, multifamily, and commercial.
There's really no commercial
crazy
component
mix.
to that neighborhood anymore. None, zero. I don't know anybody that would want to set up a commercial establishment there.
I don't know what that building is to the left, but it looked like a commercial building with a dumpster, container. I don't know what kind
The
of
one
business
that you have a
it is.
picture of? The one on the side that you have a photo?
This one is
Dean? Dean's building, that's
That's
commercial.
that's the car, it was rented.
Auto repair shop.
Yeah.
So that's a
Yeah.
commercial establishment. So there is,
No, it's not in existence anymore.
oh,
No, George Dean owned it and he's passed. I don't think it's operating anymore.
People have been in looking at it, but nobody operated there yet.
okay.
Could restrictiveness relate to the area that it's in? In other words, it would be more difficult, as you said, to put a commercial use in there. So in that case, it's more restrictive to keep it as a commercial building.
I don't see it that way. I think.
I would think restricted,
I
you
think
can't say.
restriction means the taxing, not the literal taxing, but the burden on a neighborhood. When there's retail, when there's deliveries, when there's paid patrons, when there's, that which ordinarily occurs with a retail establishment, that is less restrictive.
As opposed to code less restrictive.
Yes.
Mike, do we presently have a non-conforming use there?
We currently have legally a two-family use there that I know of, that my file shows.
And it's currently being used as a multifamily use. So it is in
That would be non-conforming.
non-conforming state.
That's correct.
But either way, it wasn't legal.
That doesn't matter.
Because either, if it was a mixed use, it was illegal, and if it's a 4-family, it's illegal. So either way, it's been used illegally, so I don't know if you'd say it's non-conforming, it's just illegal.
It originally was non-conforming because it was residential, and you were not allowed to have even multifamily in residential. Okay, so it was not multifamily, I'm sorry, two-family in the residential.
2-family was
So
only
it was a
allowed.
two-family legal non-conforming,
Right,
pre-existing non-conforming. It was okay to be there, could remain forever.
right.
Now, the store ended up there, or whatever, 2 stores, I think you said?
One store.
One store ended up there, so whatever that was, however that happened, That's the first question, and then the conversion from that store into the other 2 apartments is the other question.
The question also is,
Sorry, you're going from a two-family non-conforming to a four-family.
A 2-family legal nonconforming
Okay.
to the additions, which, or alteration, I don't know how you would do it if the apartments are upstairs. That's what I mean. Something was there. I don't know what it was, though.
To a four-family non-conforming.
I think critical to your review is to determine whether John Porco's affidavit and my client's sworn testimony, which I'd like to put him on for just a moment. I think critical to your review is to determine whether or not there was a store when my client purchased the property, my client's father purchased the property. And I submit, and I can't testify, but that store was known to me as a native of Carmel there a long, long time. And I believe that store with the apartment above was predated, pre-existing non-conforming, legal pre-existing non-conforming, because it was there forever with all the other stores. I make reference to the appliance rental and things like that. But Mr. Seno Jr. here was 18 when his father bought it, and he took part in the activities there, and he stripped the store, and they made it. So if you, maybe it's a jump that you're not prepared to take, but if you take Mr. Seno's sworn testimony and Mr. Porco saying it was a store when they bought it, then I think the interpretation we're asking you to make is not a difficult step, because it was there, and because it was, a commercial use was abandoned and a residential use was put in its place. Again, I think critical to your review is whether you believe there was a store when my client purchased it and it was abandoned the minute Mr. Uzelak sold his building.
but what you're suggesting is we're going to give you 2 for 1. You're putting 2 apartments in, but you only had 1 business.
Right.
So
Right.
we're really giving you more than, as far as restriction goes, you're getting twice as much for your money.
Well, it is what it is
Sense.
now. I mean, we're saying that it exists now as 2 down and 2 up. We're asking for you to find that which has been in existence for 40 years. And, the store which took the entire downstairs has now been broken into 2 one-bedroom apartments. And I think even with your analysis, it's still more restrictive, still more in keeping with the code, and still more in keeping with the neighborhood. So, may I ask Mr. Seno to talk with? Just tell him about your father's purchase in the store being there.
Yes, my grandmother was down in the Bronx. Bottom line is, he bought the house because she could not drive. And Fowler Avenue is within walking distance to churches and also stores. At the time when he bought it, the store was there, and I helped this person, Anthony DeVento, who converted the store into the 2 one-bedroom apartments. The 2 on the top were already there.
Okay. Have something to add?
No.
Okay. Any other questions from the board? All right. At this point, any input from the public? Okay. At this point, I'll look for a motion to close the hearing.
So moved.
Okay.
Second.
Do you guys need to, that's it for the hearings tonight on the agenda. Is there a need to take a break? Do you guys want to move straight through?
To you.
I think we should take a break.
It's fine. Good.
Okay?
This is your
Dominic.
last case. Sir?
What's that?
This is your final case.
Short night.
We're all good?
Yeah, if you guys want to stick around.
Yeah. You don't take anything from the audience by sticking around, correct? It's not open.
No, it's closed. Once it's closed, it's closed.
Thank you.
All right, Bill.
Thank you.
right, welcome back from our short recess. At this point, I'll remind everyone there's no public input on any discussion and debate, so. Number 1 was held over, NL&M Holdings. Number 2, Donald and Karen Burns. I'll look for a motion.
Motion to grant?
Do I have a second?
Second.
Any discussion? All in favor?
Aye.
All right, granted. Number 3, application of Leslie DeHostos. Do I have a motion?
Motion to grant?
Do I have a second?
Second.
All in favor?
Aye.
Okay. And on the application of Angelo A. Seno Trust, look for a motion.
Based upon the testimony today, I would like to make a motion to hold this application over, send it to the planning board for site plan review and referral.
Okay, do I have a second on that?
Second.
All right, any discussion? All in favor?
Aye.
Okay,
No minutes?
no minutes, still catching up. So, that's it.
Have a good
Thank
night.
you, folks. Have a good night.
Yeah.